Are step-parents considered legal guardians? Have you ever wondered about the legal standing of step-parents when it comes to their stepchildren? This is a topic that many people find confusing, especially after a divorce or separation. Let's break it down together. Step-parents are not automatically recognized as legal guardians of their stepchildren. Legal guardianship is a formal status that a court grants. This status gives someone the authority to make significant decisions for a child, such as those related to education, medical care, and overall welfare. Biological parents typically retain these rights unless a court decides otherwise. In the context of divorce and separation, this distinction becomes very important. Even if a step-parent plays a big role in a child's life, they do not have legal authority without going through a legal process. Without legal guardianship, a step-parent's authority is similar to that of a babysitter. They can enforce household rules, but they cannot make binding decisions about the child's welfare. If a step-parent wants to become a legal guardian, they must petition the court. This process can include background checks, court hearings, and investigations. Courts usually prioritize the child's best interests. They are often hesitant to grant guardianship if the biological parents are fit and involved in the child's life. Guardianship may be granted when biological parents cannot care for the child or in emergency situations. Some states allow step-parents to obtain limited decision-making authority through a power of attorney. This can cover specific activities or timeframes, like making medical decisions during a trip. However, this is not the same as having full legal guardianship. In cases of divorce or separation, step-parents may be recognized as persons with a legitimate interest in the child's welfare. This recognition can allow them to seek visitation or custody rights, especially if ending the relationship would harm the child's well-being. However, these rights are not guaranteed and usually requiring court approval, often facing a high legal standard. Another option for step-parents is adoption. Step-parent adoption can grant a step-parent full parental rights, but this process typically requires the biological parent's consent. Adoption also results in the termination of the biological parent's legal rights. So, to answer the question, step-parents do not automatically have legal guardianship rights. They must pursue legal guardianship or adoption to gain formal authority. In the context of divorce and separation, courts focus on the child's best interests and the rights of biological parents. This makes legal guardianship for step-parents a matter that requires careful legal action rather than an automatic status.